Great. Thank you everybody for joining us this morning for this very important call. I want to let folks know that the call is being recorded and we will send it out after the call. So my name is Karen Tumlin and I am the founder and director of Justice Action Center. I am also co-counsel in Svetlana Doe versus Nome, and I have had the honor of defending humanitarian parole in court since 2023. I am not going to mince any words with my remarks today. Today, the Supreme Court enacted the largest mass delegalization program in U.S. history, blowing past a record set only 2 weeks ago in another case. Because of the ruling today, 500,000 Haitians, Cubans, Nicaraguans, and Venezuelans, and their US-based sponsors who did absolutely everything the government asked of them can be deported immediately. They submitted bank records, they conducted interviews, they waited their turn, they paid their own way to enter the United States lawfully with the promise of work authorization and permission to live here with legal status for 2 years. The Trump administration unilaterally and prematurely reneged on that promise, ordering a termination of their lawful status and clawing back their work permits en masse. We, along with Human Rights First, sued to stop the Trump administration on behalf of organizational plaintiff Haitian Bridge Alliance and a diverse set of sponsors and people with humanitarian parole, because the actions of the Trump administration were plainly unlawful. Let me be clear. We were right on the law then, and we are right on the law now. The Supreme Court's decision today was not decided on the strength or the merits of our case, but via the shadow docket, a backdoor effort the Trump administration has used time and time again to bend the judicial system to its will. And this is a sad day. It's not just sad for our clients and our class members, but for the hundreds of thousands of other people, Ukrainians fleeing Russian invasion, Afghans who assisted our U.S. military service members, whose parole status has also been threatened by this administration, and who may now suffer the exact same fate. With me today are my co-counsel, Anwen Hughes of Human Rights First, and Gerline Joseph, the Executive Director of Haitian Bridge Alliance, our organizational plaintiff. We will hear from each of them and then we'll open the line to your questions. I want to close with just a couple more reflections. So first, I want to share just one snippet from Justice Jackson's powerful dissent issued today as well. She writes, "The court has plainly botched this assessment today. It undervalues the devastating consequences of allowing the government to precipitously upend the lives and livelihoods of 500,000 non-citizens." We are about to see the consequences now of the Trump administration's mass deportation fantasy. And let me be clear, this is for a group of people who had lawful status until this morning, but who the Trump administration has forcibly rendered undocumented overnight. And that should send a shiver down everyone's spine. I also want to be clear that today's ruling does not just impact up to 500,000 legal immigrants in this country. It upends the lives of their employers, their families, and their loved ones. In short, it impacts all of us. Trump's cruel immigration agenda is not hermetically sealed off from those of us who have the fortune to be U.S. citizens at birth. We are all impacted by this cruelty. And to all Americans who care about the rule of law, today's decision is yet another erosion of the vital protections that we used to believe were essential to the fabric of our nation and of our court system. Finally, to our clients and our class members, I will grieve with you today, but we will continue to fight on your behalf. You did everything the United States has asked of you, and you deserve much better than the decision that was handed down today. And with that, I will pass the microphone to my dear friend, Gerline Joseph.
Thank you so much, Karen, for your fierce advocacy and fighting on behalf of millions of people. My name is Gerlin Joseph. I am the Executive Director of the Haitian and Alliance, and we, along with other plaintiffs from Haiti, from Venezuela, from Cuba, from Nicaragua, from Afghanistan, from Ukraine, children who have come here in search of safety and protection, military members who are still waiting for family reunification, we continue to stand united even in the face of adversity, even in the face of cruelty. We will continue because we do believe there is strength in unity. And we still believe in the dream that we as a country, the United States, will stand on principle and will find a way to reverse those cruel, inhumane, undignified decisions that have come from the highest court of the land. It is a painful day for millions of people, immigrants and citizens alike. Today marks a new chapter where we hear a government and administration that creates a false narrative around who immigrants are, around what it means. And they toot their horns on illegality of immigration. We do believe that no person is illegal. But today, on those affected and impacted by the decision of a CHNV, we clearly see that we have a president, a government supported by the Supreme Court to remove the legal status of people who came here, who followed the rules, as they say, paid their way in, have US sponsors to welcome them. Now in their adoptive communities are facing deportation. These are men, women, children who are afraid to leave their homes, to go to school, to go to the store. Their freedom and liberty has been taken away from them. Again, make no mistake, this is not about immigration. It is about the very fabric of this United States of ours. So our call is to make sure that we continue to stand on the principle and make sure we stand on the right side of history. Again, people fleeing extreme conditions, war, political turmoil, disasters, making their way, following the rules. For my fellow Americans who strongly believes in following the rules for people in immigration to come here, this is a group of people who followed every single rule and came here with that status, and now it is taken away from them. Today, they have come for the people here in CHNV. Tomorrow, they will come for all of us. And we must believe that, and we must push, because this is unacceptable. We thank Justice Jackson and Sotomayor for their dissent, for them standing on principle, and we really are heartbroken at the status we are right now. We cannot continue to allow this administration to use immigrants and people's lives as political pawns. When we know if somebody has $5 million, they can buy their way in. This is not about criminality. This is not about illegality. This is about not wanting people seeking safety and protection the fair chance to be here, to continue to live their lives and continue to push through. It is a painful day, but I will say a couple of things in Haitian Creole for those who are here right now. Pour Haïtien yo ki la, pas découragé. N'a continué bataille, n'a continué pousser. La vie nous pas fini. Nous camper avec nous et n'a travaillé pour ça. Alors, je dis, c'est un jour qui est très difficile, mais nous pas pour compte nous. Nous pral faire une autre presse conférence avec l'autre annonce communautaire pour nous capables d'information en créole haïtien pour communauté a ka konnen exactement qui ça qui pral fait. Merci en pile. Thank you so much. Karen, back to you.
Thank you, dear Gerline. And also, just a note for reporters, we know that community members and also your readers may need information in language, and we will be working to make sure that we can provide that information both in Spanish and in Haitian Creole. I'm going to drop into the chat an email that you can email so you get information on our separate and additional Spanish language and Haitian Creole media press calls. With that, I would like to turn it over to my co-counsel, Anwen Hughes, so that she can share her remarks on today's ruling.
Hi, thanks so much, Karen. I think I'm still in the digestive phase of reaction to this decision. A couple of things I would say. One is I think my colleagues have laid out, and I think most of you and all of the communities that we're representing here understand the devastating impact that this decision can have on them. What's also troubling to me about this is not even beyond the Supreme Court's willingness to grant the government a stay, is also the underlying government policy that we're challenging here. In other words, DHS's decision and the administration's decision to focus on this particular population as a particular target of its ire simply because they avail themselves of a legal policy that this administration doesn't like. We're going to be continuing to have a legal debate before the courts as quickly as possible, I hope, about the legality of the administration's decision to end that program. But focusing on these particular parolees to try to focus on them for removal and to strip them of status that they came by lawfully, in the same way that the administration is also focusing on people who show up for their court hearings as targets for detention and removal, is making all of these people punch balls in a political debate that they did not generate. They're not part of this. And I think that's extremely troubling. I think it's also very troubling, and it calls into question the US's commitment to refugee protection principles that have been, part of our foundational narrative as a country. If we're saying to people that they can't come here simply by showing up at the door and knocking, they also can't come here by prior appointment. They also can't come here by going through this parole process to get themselves out of conditions that range from family separation to extreme economic hardship to the need to escape from persecution and active war zones. What exactly is it that we are telling people? What exactly is it that we're telling people the United States is still prepared to do, to protect people and to enable the reunification of families and to enable communities to welcome those they want to welcome? So as Gerline was saying, the struggle continues, and it's going to be continuing now before the First Circuit Court of Appeals. And we will be there for that. But, there's no sugarcoating what has just happened here and what it says about the court's willingness to protect rights of this magnitude and about the administration's willingness to, delegalize 500,000 people at the stroke of a pen.
Thank you, Anwen. I'm going to turn it over to Tasha, my colleague, so she can tell people how they can ask questions, because most importantly, we want to do our best to answer any questions that you have. Oh, and I see the first one is coming in. I'm going to read the first question, which definitely lets me know that people can type your questions into the chat. But Tasha, let us know if folks can also unmute to ask. So the first question that I'm seeing is from Veronica at the Miami Herald. It's a two-part question. First is, what legal avenues, if any, remain available in district court for CHNV parolee recipients following the Supreme Court's ruling? And the second is there any way to track down how many affected individuals have filed for alternative forms of relief, such as asylum or adjustment of status, and whether any of those applications are likely to be granted? I can start, and then Anwen, you should also chime in. So I want to really emphasize, and we can talk about this a fair amount. On your first question, like what else can be done? This is the shadow docket. This is not a real ruling on the merits of the case. It is a temporary decision. So there's all kinds of things that can still be done in the district court and going on to we hope and we believe ultimately win this case. And so we're not one to foreshadow our entire legal strategy before we've moved in district court for anything further. But to be clear, this decision was an initial decision before the United States had even given us the administrative record of why they reached this decision. And so while it was labeled actually a stay, or sometimes you might consider that a preliminary injunction from the district court, it's not a final ruling after a trial or a summary judgment decision. So all of that remains to happen in district court below. And we're committed to ensuring that our clients and the class members get a full and complete hearing as quickly as possible on their legal claims. Separately, on the how many people have applied for what. So we have a tiny snippets of information finally because what's called the administrative record was recently produced by the United States government in the case. And I think that what I remember from seeing that, and Anwen, you can correct me if I'm wrong, is so number one, we don't have total estimates of the number of people impacted. We know it's over 530,000 people were on CHNV as of December 2024. And of that, at least 250,000 of them had something else pending, had another application pending. At the time, the US government tried to invoke, cancel their CHNV grants and issued a separate memo saying that nothing else that you apply for if you entered under CHNV will even be processed. Just this week, that bar on processing other applications, whether it's asylum or TPS or adjustment of status under the Cuban Adjustment Act, that was lifted this week, and those should be processed right now. It's a great question to ask the United States government what had they have done to ensure compliance with that court order. Anman, what would you like to add on any of these questions from Veronica?
Well, to Veronica's question about whether any of these applications have a chance to be granted, I would say on the merits, based on some that I, have some personal knowledge of, um, they should be. And, a lot of people were approved for parole under these programs because they were, with the idea that they would be pursuing other forms of relief once here. And that ranges from, immediate relative petitions that would allow them to adjust their status, which are a fairly routine thing that, is pretty routinely approved when people meet the requirements. And other people have asylum applications pending, some of which are exceedingly strong. Others are pending as derivatives on the applications of other family members with whom they were seeking to reunite. So just to emphasize what Karen is saying, I think it's an excellent question for the government, what they're doing to give effect to Judge Talwani's decision of this week, which should allow those people to seek other resolution of their status based on those pending applications or other applications that they may be filing at the moment or in the coming days.
Okay, so yay, I'm seeing lots of questions. I am told that Tasha can unmute you if you want to ask your question live. You can also raise your hand to let me know that you want to ask a question live. And I think that I've got some questions queuing up in the chat. I think Maria has her hand raised, so let's hear from Maria. Tasha will unmute you, and then we will go to Annabelle.
Thank you very much for having this so quickly and for answering our questions. I did want to I follow up on that earlier question about the legal status of folks. I mean, my understanding is that the Biden administration did not renew parole, right? So if there were 2-year grants, do we know how many of those grants expired already of the 500,000? Also, for instance, Cubans, I know folks were applying for permanent residency under the Adjustment Act. Just trying to put this 500,000 number into perspective. I understand that thousands could be at risk of being deported, possibly without a hearing. But trying to understand like how many people really could be affected by this.
Yeah, so to our best knowledge, and we have a footnote about these numbers in our brief to the Supreme Court, Maria. But so the reason why we say about 500,000, again, we're obviously using the government's own data. The best and most current data that they gave us was that there were 530,000 individuals on CHNV as of December 2024. Now, here's the issue. I believe that the number of people today who had current or who, as of last night, still had time left on their CHMV grants is a bit under 530,000. The reason for that is that CHMV is different, parole is different. People come in at different times. Each month, 30,000 individuals could have been given permission to travel in and to enter, be subject to their interviews at the airport arrival and come in on CHNV. So not everybody's grant started on the same time or ends on the same time, but some amount less than 530,000 were valid as of last night. Of that grouping, we know from the data the government has recently, it was only in the last week, produced in our case that at least 250,000 of them a few months ago already had something pending. So before this Federal Register notice that told people that they were going to try to take back the grants early, already over 250,000 people had tried to avail themselves of another pathway that they were eligible for. And so certainly that number has only gone up since that time. The issue was that no one was processing those applications. And now, as of Tuesday of this week, they should have been processed again. So that's kind of the impact. I will start on, what does it mean? Can people be deported right away? But Anwen and Gerline, if you want to add anything, please do. So right now, as of the Supreme Court's ruling, it's immediate. There's no like lead up period. So as of now, even if you had 21 months left on your work authorization and your CHMV status, that is gone. That is no longer in place. But what does that mean? It means that if that person is either tracked down by immigration officials, right? Immigration could decide we're going to now try to go after these people and detain them and remove them, or they may just encounter immigration officials in their daily lives going about their business. If that happens, we believe that they must be put into full and regular immigration court proceedings and have a full and fair day in court. And that's essential when somebody already has a pending application for something else and could be removed to a country where they will be persecuted or killed. However, the United States has said that they believe that these individuals can be placed in short form summary deportation called expedited removal, where they have no right to see a judge. We do not believe that's lawful. The district court below didn't believe it was lawful, and the First Circuit affirmed our view of the law, which is that individuals granted parole cannot be put in to this short form procedure. But this is what we're fighting about, and it really matters, obviously, for these folks and their families and people who love them. Anwen, anything else on Maria's question? And then I see Nina has her hand up too. Okay, I promised we'd go to Annabelle. Annabelle, let's do you, and then we'll do Nina, and then I'll take more questions in the queue. Annabelle?
Hi, good morning. I think you answered some of it in this last question, but maybe there's something else you want to add. My question was if folks who are under this program are immediately under the threat of deportation as a result of this decision.
Yeah, I think we did cover it, Annabelle. Yes, they are. They absolutely are. And I think it's more important than ever that they know what their rights are. I think the first is that they should have a full and fair day in immigration court where they can put forward their case for their any other pending applications that they have, and certainly whether they would be persecuted or tortured if they're removed from the United States. Okay, Nina, we'll go over to you.
So I'm curious to know what you make of this stay. Whether you think, I mean, since we have no idea how the other justices actually voted, except that a majority of them cleared the way essentially for the administration to start the process of getting rid of parolees, whether or not they have more time essentially available to them. So I'm curious to know, since there were only two dissenters noted, what, in your best case scenario, since you now go back to district court and the Court of Appeals, and presumably those courts can speed this up because they're now familiar with this case. In your best case scenario, not your worst case one, how do you get claw back most of this?
Yeah, it's a hard question. I think that, and I'll give you kind of my Supreme Court crystal ball readings and on when you should do the same. Um, it is striking. So first of all, unlike the TPS decision, we have a written dissent here. I do think that this stay, coupled with the stay in the National TPS Alliance case, does tell us something very disturbing about the willingness of the majority of the justices to allow shadow docket stays to be granted despite the numerically huge impacts on humans and their employers and loved ones. I think our best case scenario, in my opinion, is to expedite the what is remaining of the case. We have already, before this, we had put in an expedite request jointly with the federal government to the First Circuit. But within the district court, we now do have what we need from the federal government, which is the administrative record to say, okay, the record here is closed. Let's go forward. We believe that this was unlawful to do a mass termination at the outset. Now let's do what's necessary to bring this case to final judgment. But the truth is, that takes months. Even when a district and a circuit court are expediting, it could be 7, 8 months before this comes up to the Supreme Court again. I will say that I have been kind of reckoning with my own experiences in cases I've been involved with, both with the Muslim ban and then with the Remain in Mexico case. In both those cases, stays were granted on the shadow docket by the Supreme Court. In one case, when the case went to the merits, the result was the same. That's in the Muslim ban litigation. In the Remain in Mexico litigation, everybody said, oh, once you lose on a stay, you're going to lose on the merits. That is not what happened when the case went back up. And because of the human impacts, because of the gross erosion and evasion of basic legal principles under the Immigration and Nationality Act, I am hopeful that that will be the result here. What concerns me is the human damage in the interim, and that we have to talk to our clients today and our class members about navigating a catch-22 that Justice Jackson talks about powerfully, that the district court talked about powerfully, which is what do you do in the interim while the wheels of the justice system turn? Anwen, pull out your crystal ball and let us know what you think on these questions.
I have never claimed to have a crystal ball into the thinking of the Supreme Court, and less than ever do I have that now. So I'm going to abstain from that one. But I would certainly agree that I don't think that a decision to grant or not grant a stay, at least judging on historical experience, is necessarily determinative of how things play out in the full litigation, and we're certainly very hopeful that that's not how things play out here. To Taiki's question about, if these people filed asylum applications, for example, does that give them any protection from removal? I mean, the answer, even on DHS's traditional view of how the law works with the intersection of humanitarian parole and pending affirmative applications, is yes. I mean, it does, and that when you file for asylum in the United States, you may not be in lawful status, quote unquote, but you're here with the consent of the United States government until there's a final administrative decision on your case. That should still be the case here. I know that we have striking disagreements with the government as to their interpretation of the law and what process people are entitled to upon the termination of their parole. But normally, and I should say, the United States has used humanitarian parole for decades as a means of getting people to the United States whom the United States felt should be gotten to the United States when the regular visa process wasn't a viable option for various reasons. I've myself worked on the case of a lot of high-profile dissidents over the years for whom this was used. They then applied for asylum in the US. If their humanitarian parole ended during that time, that didn't really affect the process. Their applications for asylum could be approved affirmatively. This is the low-cost approach, frankly, for all concerned, both humanly and administratively and bureaucratically. And, I do think it bears emphasis, as long as we're talking about harms, that the harm to the government here was what exactly? I mean, this this stay order didn't give anyone status that they didn't otherwise have. It didn't give anyone any more lasting legal obligation or legal options, excuse me, that they didn't otherwise have by statute enacted by Congress. All it was simply saying was, let this parole expire when it would naturally expire, and let people proceed to, well, this is actually the second stay order that we got here, is let people continue with the adjudication of whatever other applications they may have going.
So
Just
what's the status of that? I mean, in other words, so let's say I'm done. I'm cooked. So, but I have an asylum application pending, and perhaps something else pending. But just because the norm in the past was we would let it play out, that doesn't mean the norm currently will be the same thing, right?
No, it doesn't necessarily. I will say, though, that there is a separate stay order, which is still in effect as of now, which requires DHS to continue processing those applications in a normal way. So, or that is to say, it stays their decision to suspend the processing on those applications,
And
to be
where is that
precise about it.
order? Where is that order from?
From Judge Talwani.
In Massachusetts?
In Massachusetts this
Okay.
week. So, in other words, there were sequential complaints filed in this case because DHS didn't do everything it was planning to do in one fell swoop, and the court had issued thus far two stay decisions, one of which was specific to the issues raised by the Federal Register notice that terminated the CHNV parole program and also clawed back individual grants so terminated prematurely individual grants of humanitarian parole to people who came in through that particular program. But there was an earlier memo that applied more generally that ordered DHS to suspend processing on the later applications for immigration status or benefits filed by people who happen to have come in through specified categorical parole programs. And that was something that was covered by an earlier iteration of our complaint in this case in district court. And it's something that Judge Talwani issued a stay decision on. Time is collapsing for me, but I think it was 2
Tuesday.
days ago.
Mm-hmm.
Tuesday, yes, Tuesday. That
Could have
was
been
2 days ago,
Wednesday.
right?
Who
Yeah,
can
okay.
remember?
Yeah, thank you.
Just
So
this
I don't want to
just
get this wrong. So just can you just say in one or two sentences what the judge ordered in terms of processing
Sure.
for your class?
Sure. So I'll give it a go. So first of all, Nina, I'll say it in a couple sentences, but also this is all on our case page, which Tasha will drop in the chat. All of this is the same lawsuit before Judge Talwani. But what she issued this week, so she did two things. It was two new decisions this week, a new class certification order. So to be clear about that, everything that happened today was on two prior decisions, a first class certification for the CHMV class only, and first the stay of the Federal Register notice saying everybody is out of status as of April 24th. That's what happened today. Earlier this week, we got a separate decision and a separate set of classes certified. Yes, it includes the CHMV population, but it also includes a whole bunch of other parole programs, Uniting for Ukraine, Operation Allies Welcome for Afghans, Central American minors, 7 different family reunification programs, military parole in place. All of those had any, quote, any pending immigration benefit application paused, and they were not being processed. And the judge said, too bad, so sad. Pick your pencils back up, and you have to process them in the original course. Your blocking of them is arbitrary and capricious. It violates statutes, a whole bunch of them, and you have to go back to resuming processing just like normal. It doesn't mean for any one of their named plaintiffs you have to grant them. It means you have to do exactly what you would have done before you blocked everything. And then she certified it classes for all those folks, both for re-parole applications and everything else, asylum, green cards, employment visas, diversity visas, you name it. Nina,
Mhm.
does that help? And anything last before I go to Tai Chi?
It helps, but I think I can't get into it actually. It's too much material.
It's a
I just
lot
have,
of material. We've
it's
got
a
a
lot
lot
of,
of kind of summaries. I mean, the main thing you need to know is What happened to the CHNV population today is probably coming soon in an effort to delegalize a bunch of other populations, including, for example, Ukrainians. Taichi can.
It's Taiki Hendricks.
Taiki, thank
Yeah,
you.
KQED. Yeah. And yeah, just to follow up on Anwen was talking about, in ordinary times, if somebody had a pending asylum claim, the government wasn't going to move to remove them. What have you seen thus far under the Trump administration with people with pending asylum claims? Have we seen people removed through expedited removal? Is that a real, like, active practice that's a threat now to these folks, or is it just
Yes. We have seen just in the past week a rash of arrests at immigration courts of people who have applications for asylum or other relief pending in regular removal proceedings where the government has, well, DHS has been going, ICE specifically, has been arresting them when they show up to appear at their hearings, which is, of course, the thing that the government has ordered them to do and which they are therefore doing. And so, the point being that people who the government's view has been that if people came into the United States less than 2 years ago, that they are amenable, in the government's phrase, to expedited removal, and that they can do that to basically short circuit the normal process before the immigration courts. Now, I will say, DHS is still obligated to give those people, even if you assume that they're legally correct and that that is a possible thing for them to do in the cases where they're doing it, or in the cases of our class members, they would still need to provide them with credible fear interviews for those who have a fear of return to their home country, with which many of them do, and that's why they're here, right? So, and if they pass those credible fear interviews, then they are exactly back in the process that the government is now trying to strip them of, in the case of these immigration court arrests and immigration removal proceedings, which does rather beg the question whether DHS has an intention to provide a fair process. Because if they do, then there are very limited efficiency gains in any of this. But yeah, so to your question, is this actually a meaningful threat? Yes, I think we would consider it to be a meaningful threat, absolutely.
Okay, and I know I'm not ignoring all of you with questions in the chat. We're going to make sure that you feel like they've either been answered or get to you to have any follow-ups directly. But before you do that, I know that so far many of these questions have been about the legal proceedings, and that's because we got a Supreme Court order this morning. But really, the case is about people, and I just want to make sure, Gerline, is there anything that you want to add after listening to the questions so far about the consequences from your perspective, for the people that Haitian Bridge Alliance works with, or anything that you feel like we need to add at this point?
No, thank you so much. And I think we really need to understand that the Trump administration has, as of today, really started to delegalize immigrants who actually are here, quote unquote, legally. So when we hear the narrative and we really want to push back on that, and we are asking the media to please use the proper language to make sure the community and America understand what's happening. When we hear the narrative of illegal immigrants, please correct that language, because those who are documented, the rug has just been pulled under their feet, and that impacts millions of Americans who have sponsored those people, who have welcomed them into their homes, who have provided the adoptive space for them. This is way more than just immigration. It has nothing to do to legal or illegal immigrants. And we do see how this administration continues to prioritize certain group of people under false precept to welcome them in the US. So it is not a matter of unable to welcome and care for people with dignity. It is a game of really putting people in danger and forcing them to become second, third class citizen. And as a country, we cannot allow this to be the norm because history will judge us harshly. We are going back to a time where we have children that are so stressed, so traumatized, so terrorized, they cannot go to school, they cannot learn. They are afraid to step out of the home. So now put your place in the shoes of people who are here seeking safety and protection, who have followed every single rule that has been put in front of them. And now we have literally pulled the rug under their feet. It is unacceptable. It should be unlawful. It should be, this should be considered, honestly, to be a crime against humanity for what we are seeing right now. Because we know if you have $5 million, if you have the right connections, even families of other people are able to allow to come here. So it is not about criminality. It is not about legality of immigrants. Is it about cruelty, pain, terror, stress, and trauma? Thank you so much.
Thank you, Gerline. Ralph, I want to make sure, have we answered your questions? Do you have any follow-ups we haven't gotten to? Hi,
No,
Ralph.
thank you so much. Thank you so much. Thank you.
Okay, sounds like you might be good. I have, oh, I'm gonna mispronounce your name and I apologize. Machiavelli Neal from the Haitian Times. Do you still have questions that we have yet to answer?
Michael.
Hi, yes, hi. Thank you so much for holding this call. I mean, you spoke in at length about the human toll, and that's really what we wanted to get at to try to explain the implications of what this all means for our, our community, the Haitian community across this country. And so some of the questions we had gotten were, can I go to school tomorrow? Can I still go to work? Those types of very, basic, immediate questions are what our community is wondering about what they can or can't do when they wake up tomorrow morning.
Oh, it's hard. And honestly, I mean, I know that you know this, it's person specific, right? What they can or cannot do. What I can say for everybody who had CHNV is that as of this morning, once the Supreme Court ruled your work authorization was no longer valid and your grant of parole was no longer valid. So what that means they can or cannot do, it depends on have they applied for something else? Because of that pending application, are they eligible for another work authorization? Have they already been granted something else? It's very much going to be a person dependent answer. But the gut punch, the thing that is, making my heart very ache this morning, that is causing the fear that Gerline spoke about for children regarding their parents or for themselves, is the simple fact that they can no longer rely that the 2-year promise they were made from the US government that has been revoked as of this morning. Anwen, would you add
May I
anything?
add something
Yeah,
really quickly, just to
sorry.
clarify? That's why we continue to ask the community to contact a reputable organization or attorney to see what their options are. And we keep on asking people even now if they have applied for TPS, have applied for asylum, other type of relief that they might be qualified for. So we are really praying that a lot of people have had other avenues for relief. But again, as my dear sister mentioned, this is a moment where people who have not applied for any other type of relief as of today, the government have chosen to remove any type of protection that they had under CHNV.
Right. And just two things I would point out, one of which may be overly obvious, but let's do it anyway. People who have, for example, been granted asylum or been granted TPS that they applied for after coming in on CHNV parole enjoy that status. indefinitely in the case of asylum, or until the TPS termination date in the case of TPS, right? So that's not what we're talking about here. Those people should not feel like they're suddenly becoming undocumented as a result of this decision. I think for people who have things that are pending, and for people who have relief that they're eligible for that they may not have applied for yet, I would suggest that they seek competent legal assistance in assessing that and or doing it as soon as possible, because as Karen says, it can be pretty specific, case specific.
Thank you. Thank you. Okay. I believe that the people that need to see if they have any more follow-up questions is Maria, Jack, and then Yola. Maria, do you have any more follow-up questions you want to ask us?
Yes, I do. I put
Great.
in the chat, but and I'm sorry, but it was about the 250,000 who applied for another legal status.
Yep.
And I'm sorry if I missed it. But can they be deported via expedited removal while those applications are pending? Like, can DHS cancel them? And can they do it even if they've been here, put them into expedited removal, even if they've been here longer than 2 years as quote, and I apologize if I'm doing something wrong here legally, but like as arriving aliens, is that something? So is
Yeah,
I'm
yeah.
just wondering, like, what if I have a pending claim, should they be worried or not?
Okay, so here is our position. This is going to be a forthcoming legal fight. This was part kind of wrapped into the legal questions that were before the district court already. So our position, the expedited removal is a statute that, as folks know, it was passed in 1996. It was implemented on January 1st, 1997. The wording of that statute says that it cannot be applied if you were, quote, admitted or paroled. Our argument is real simple. Parolees were paroled, you had CHNV, you came to this country with pre-permission, with the little parole stamp, and you cannot be put in expedited removal, full stop. The Trump administration does not agree with that. They take a different reading of the statute. It's kind of tortured because they are making some arguments about like the perfect tense and other things, but this is going to be a fight, right? We would say, we maintain, we have a separate case about this as well called Chirla versus Nome. It is pending in the District Court of DC because the only place in the entire country where you can challenge changes to the expedited removal policy is in one courtroom in the District Court of DC. So this is going to be a fight. I would argue no, they can't be put in expedited removal. But the Trump administration told us when they tried to terminate all of these grants of CHMV early, they said they wanted to do it early precisely because if people have been here for 2 years, they can't put them in expedited removal. And so they want to end their grants early so they can. And what does that mean? It means people will be whisked away without proper assurances that they are not going to be removed to a place where they will be killed, tortured, or persecuted. So this will be an ongoing fight in the district court below in Boston and in our separate case. And it is very dicey. And it's why Onwin's advice, what I have been saying, I think is really important. People need to get individual immigration advice and they need to advocate for why it is that they have fears of return, if they have fears of return, and should have a chance to see an immigration judge. Okay, I know we're short on time. I want to see, Jack, do you have any follow-ups we haven't answered yet?
Hey, yeah, thanks, Karen. I think sort of related to all these questions, but for people who haven't established themselves in other pathways, asylum, TPS, et cetera, what are the pathways that are available to them at this moment, like those 250,000 or so? Is TPS, Convention Against Torture? What are the sort of what are the options available to them at this point?
Well, I mean, the options are whatever they may be legally eligible for. That is to say, there were some people who came to the United States through these categorical parole programs with the intent of remaining in the United States temporarily and then returning home. There were some people who, very much saw this as a temporary thing. But for a lot of people, it was a means of coming to the United States legally in order to secure more lasting protection. I think there are some people who have eligibility for forms of relief that they simply haven't filed for yet. And there's nothing in today's decision that prevents them from doing that in itself. So I think they would be well advised to do that as quickly as possible. And as Karen notes, there is going to be this other procedural fight over how these cases are understood procedurally and what process the government can and cannot follow in attempts to remove them from the country while this is going on.
Yeah, and I'll just tick off a few quickly, and then I'm going to check on Lawrence and Jacqueline, who I think still have questions. So, like, it's a plethora of options of other things you could be available for. And our clients have like shared with us some of the things they've applied for. Some of them have employers who have sponsored them for employment-based visas, H-1Bs, and other things that were not being processed until this week. Some of them have won the diversity visa lottery and they weren't getting their interviews either until this week. Some of them, right, the Cuban Adjustment Act is actually a pretty speedy way if you have qualifying family members to to move from CHNV parole status as a Cuban to a green card. There are so many ways. Some of them happen quite quickly. Some of them are family based, some of them are fear based, and some of them are employment based or diversity based like the lottery. So there are just so many ways, and this is how our immigration system works, right? A lot of people come in on a temporary status and then transition to a more permanent and secure status, but they qualify for something that Congress has articulated they have a right to apply for. Okay, Lawrence, do you still have a question? And if so, please ask us.
Hi, can you hear me?
You sound great.
Great. Yeah, I just wanted to, I might have missed it earlier, but can you just clarify other countries, people from other countries that have also been subject to parole programs that the Trump administration wants to revoke, and just mention which ones? I think you mentioned Ukraine, and also, how much this decision will help them to do that.
When you want to give it a go first, and I'll fill in
Sure.
any
So
minute.
there are a number of these categorical parole efforts, by which we mean situations where the government expressed a sort of categorical willingness to consider parole on a case-by-case basis for people who fit into certain defined categories, right? And so in addition to CHNV parole, there is also what was known as the United for Ukraine parole program, which was set up very shortly after Russia's invasion of Ukraine in 2022, with the goal of getting a bunch of people to safety in the US who needed to get to safety in the US. There is also what was known as Operation Allies Welcome, whereby the United States paroled into the country a bunch of Afghan nationals whom it was evacuating from Afghanistan in the wake of the US withdrawal in 2021. There was a reparole for a lot of those arrivals, so many of them may still be covered by parole status. There is also something known as military parole in place, which allows service members to sponsor for parole from within the United States their family members to prevent family separation while people are serving in the armed forces. And what am I forgetting? I think that's a lot. And so in terms of this decision, I would say CHNV parole is the only program with respect to which the government issued this a termination, a clawback of individual parole grants through a federal register notice. So they haven't done that with respect to any of these other parole programs. It remains to be seen whether they intend to do that. A lot of those programs, people who parolees under those other programs, many of them were also affected and have been affected by the suspension of benefits processing, the suspension of processing of their subsequent applications for immigration status or benefits. So we are hopeful that those people will be able to see their cases move forward. But this decision does not have a direct impact on people who were paroled in under those other programs, and in terms of its potential effects on the government's legal strategy, that's something I'm not going to speak to.
Okay, I think We have kept you all long enough, but Jacqueline, I'm going to let you have the last word, and then Gerline have the last word, which feels quite appropriate. So please let us know what your question is, Jacqueline.
Yes, hi. Thank you, sir. I'm in my car. So when this decision was taken, CHNV and Haitians were added. It was specifically because of the humanitarian and security crisis in Haiti, as well as the fear in terms of a migration crisis on the shores of Florida. And Gerline, I'm just wondering if you can specifically talk about the fact in terms of the particular impact to Haitians when you think about they don't have the Cuban Adjustment Act, they have low approval rates on political asylum. What are they being sent back to here?
Uh, Thank you so much, Jacqueline. And you know better than anyone the conditions in Haiti and the government themselves. Every single person within the government, current administration will tell you that the conditions in Haiti is dire. They continue to be a part of what's happening in Haiti. And we are close to 1 million internally displaced people in Haiti. Um, the capital has been overtaken by armed gangs members. So they call them gangs, but they are well organized, well armed, well financed groups that continue to terrorize the population. And it is not just in Port-au-Prince, it is in Jeremy, it is in Lotibonite, it is in multiple areas in the country. And earlier this week, we saw drones that were literally being used to annihilate complete areas in Haiti. So to have this right now for the Trump administration to find it okay to send people to Haiti right now is unbelievable. It's unconscionable. We don't even understand the narrative behind it other than cruelty, racism, and all the things that we continue to see that they do. So we are calling on the administration to reconsider their plan, and we are calling on the American people to voice their concern against this extreme conditions. And we are asking the community to stay vigilant, to make sure that they take care of themselves, take a moment to breathe. This is not the end. As you heard from our legal team, we will continue to push. However, as of today, many lives are at risk. And we know that deportations continue to go to Haiti every single month. So we are really pushing back and trying to see what's the best way moving forward, Jacqueline. But as you know, the conditions in Haiti is not a space where we can send people back to right now.
Thank you all for being with us and for your questions. I want to remind everyone that if you have any follow-ups as you're writing something or preparing your own stories, please just email press@justiceactioncenter.org. That's press@justiceactioncenter.org. We will follow up with you. If we didn't answer your questions or any of your follow-ups, we will get on that. And my deep love and appreciation to Anwen and Gerline for your brain and your heart and your commitment to supporting your clients and your community, no matter what we are facing. And we will keep doing that. Wishing everyone the best day possible. Thank you.